Good morning, everyone. Welcome to this week's episode of the Commerce Committee. My name's Kevin Vaughn. I'm your host. Has everyone gotten a chance to put your login in so that we may take a roll call? I'll give you about 20 seconds, and then clerks, if you could give us the board to sign ourselves in so that we can have data for posterity indicating our attendance today. Look at there. Madam Clerk, would you take the roll?
Mr. Chair, you have 17 members present. You have a quorum.
Outstanding. We've got three very important items on our calendar today, but prior to us getting started with the people's business, did any members have any personal orders? I have one. Representative Hemmer.
Thank you, Mr. Chair. I want to welcome a guest today. We have Mr. Rick Boyd today in the audience. Please make him feel welcome. His family-owned Ford dealership here in Nashville. As third-generation car dealer, his family runs Mid-10 Ford, and he also serves the current chairman of the Tennessee Automotive Association, represents Tennessee's car and truck dealers.
I see him sitting out there with Tim Slattery as well. Outstanding. I'd like to welcome a new committee member. I see our newest subcommittee chairman for business and utilities, the Reverend Rusty Grills, is with us here on a full-time basis now. We've been keeping your seat warm for you. We're glad you're here among us. Who else has their hand up down here? We'll talk about cover later.
Thank you, Mr. Chair. I also was going to give props to our new subcommittee chair and also let you know that my son, Reagan, works for Ballot Health, and they are watching Commerce Committee today. So he's tuned in to see the very most exciting thing happening in all of the state of Tennessee today under your fearless leadership, Mr. Chair.
Is it Todd?
It's Reagan.
Oh, Reagan. Hey, thank you, Chairman Faison, and for young Reagan. Just think, these people have your future in their hands today. Buckle up and let's hope we handle it with care. All right, folks. We're going to, without seeing anybody else offering any other words of wisdom to future generations today, we're going to start with our calendar. And first up, we've got House Bill 1034 presented by Representative Alexander. All righty, we've got a motion and a second there, Madam Sponsor. I also see that we may have a amendment working with it. I know that was a very diligently worked amendment.
Yes.
That I'd like for you to share a little bit about with our committee after we get that thing attached.
I have 012379. Is that correct?
That is correct. We've coordinated that. I've got a motion and a second on that. Let's get that amendment attached. I believe it rewrites the bill. All those in favor of attaching 012379, which is amendment number 1 to House Bill 1034, please indicate by saying aye. Aye. Any opposed, no. Your bill is now in proper posture. Why don't you tell us about that amended bill, Representative?
Thank you. Last year, you will remember that I came to you with a non-compete bill. It was concerning someone in my district who had had a non-compete clause for 2 years. They had removed him from his position for no fault of his own other than that they were reorganizing. And But they wrote him a letter saying, this is no fault of your own, but we no longer need your work. He had been with them over 20 years, making a lot of money selling medical supplies. What happened to him was they paid him a 1-year severance, but they wouldn't let him out of his non-compete, which was 2 years. So for 1 year, this man in his 50s could not find work, because no one wanted to buy out his non-compete clause. So I was concerned about, a lot of people came to me with concerns about non-compete, from the Chamber of Commerce to the NFIB to the Music City industry. And I said, well, then let's get around a table. Let's talk and let's see what makes sense about a non-compete. So I asked you all last year to let me pull it back and work on it for a year, and we did do that. We got a lot of people around the table, including Office of the Courts, everybody involved, saying, what can we do to make this right in our state? And so we came up, we also looked at other things that were being done in other states that were next to our state. And we looked at what Georgia was doing, and it made the most sense to what we needed to get started here in this state. And so here's what it does. The bill establishes rebuttable presumptions for how long a restrictive covenant is considered reasonable in the state, giving courts and businesses clear guardrails instead of a case-by-case uncertainty. It sets up reasonable thresholds based on that relationship. For example, up to 2 years for an employee non-compete, up to 3 years for distributors, franchisees, dealers, and licensees, up to 5 years for covenants tied to the sale of a business. The bill prohibits non-compete agreements for employees earning under $70,000 annually, ensuring non-competes are used only where they are most appropriate and defensible. Employers may still enforce confidentiality agreements, customer non-solicitation clauses, and employee non-solicitation agreements. It allows courts to modify, not automatically void, agreements. Courts retain authority to alter a covenant to make it reasonable rather than throwing it out entirely, encouraging fair enforcement instead of all or nothing outcomes. And that is my bill.
Representative, do we have any questions for our sponsor? Chairman Clemens, you're recognized.
Thank you, Mr. Chairman, and thank you, sponsor, for this legislation. This has been an area of the law that I've dealt with on both sides, from small businesses and employees as well. So my question is, we're allowing certain rebuttable presumptions with regards to 3 years or less, 5 years or less in certain instances, and
2
we're
years and less.
Excuse me?
And 2 years
And 2 years less.
Excuse me.
And that eliminates any consideration of the duration, the geographic scope or the employer type. Am I correct in that? Because those are highly relevant variables. Now, I think they're inconsistently applied sometimes in my experience from court to court. And so I understand the need to provide definite guardrails, but you have different specialties of employment, you have different skill sets, you have different training that's conducted, and then so I kind of see this from both ways. So are we eliminating those variables and just saying anything under 3 is allowed, anything under 5 is allowed, anything under 2 is allowed, and if this?
Madam Sponsor.
Okay. They have very, so for example, for 3 years, that's only for distributors, franchisees, dealers, and licensees. This is just a basic bill. It doesn't get into the weeds of what if you have a hospital that has non-compete for its doctors. I have that in my region. And what we find out is that sometimes when a doctor works for a hospital, they're tired of doing all night, long weekends and everything, and they're aging out. They want to go to a private, private practice, for example, and just do patient care during the day. In some of my non-competes in our area, they say you have to get 50 miles out of the region. And so that means I've lost a doctor in a rural part of health, because once they leave a 50-mile radius, that's it. But this bill does not address any of that. It just gives some start guidelines. Does it mean, sir, that we don't need to go back and relook at things and get it more in depth?
Okay, I just wanted to make sure on the record that it was limited to certain things and
Yeah.
didn't have a broad
Yeah.
stroke. So thank you. I appreciate that.
Thank you.
All right, you good, Chairman Clemens? We're going to go to Representative Boyd. Leader Boyd, Whip Boyd. We're going to this gentleman over here with the finely coiffed beard.
Thank you. Thank you, Mr. Chairman. Sponsor, I just wanted to clarify. I've heard you mention several times employer-employee relationship. Would this also extend to those people that were independent contractors with a 1099?
Madam Sponsor.
This bill does not address that.
Okay, thank you.
Thank you, sir. Representative Lynn, saw your hand up as well.
Is it on? Okay. Thank you, Mr. Chairman. So we have the 2 years, the 3 years, and the 5 years, those categories. Is there anything in the law right now regarding those categories?
No,
Sponsor.
Okay.
excuse me. No, there is not.
Okay. And I apologize that I didn't look at the current law
that's
and
fine.
look that up. I'll tell you, I like the part where it prohibits non-compete agreements for employees earning less than $70,000. Just part of me kind of feels that if you put a period of, say, 5 years in there, that's going to be what they choose. I've heard of people selling businesses and they have a non-compete for 1 year. And then sort of if you dress the law and say 5 years, they're probably going to pick 5 years. And 1 year will not be the case anymore. And that's just my concern. You know, it may pass and we'll see what happens going forward. But I like the part about addressing the employees earning less than $70,000. I think that's completely fair. The other parts, I don't know that we need to address that, but we'll see what happens. Thank you.
Thank you, Representative Lynn. Folks, this is your chairman's take on this bill. Representative Alexander identified a problem and what seemed to be an injustice and is working towards an area that has had not much involvement from this body in moving forward. It's been 100% left to the
Court.
jurisdiction of whatever court you wind up in, and then you get into individual judges' concerns or whatever their beliefs are within this, their study, their experiences. And so what we're trying to do here is make a first attempt at put some framework to where people can understand what decisions they're making when they execute these and what provisions that they have a dispute that what statute says that may help them if they feel like they've been treated unjustly. I think it's a good first step. I don't think it's our only step. I think that this is one of those areas that we probably will come back from year to year that people will figure out that, hey, there may be some things that we either didn't go in depth enough on or areas that we might need to tweak as we move forward. But I personally, from my perspective, I believe this is a great first step to at least leveling the playing field a little bit with regards to what is fair for people when they leave the employment of another company. And so with that, if we don't see any other questions, hey, Leader Cochran, I see you there.
Thank you. Hey, just one quick clarification, Representative. So earlier, it was asked, does this apply to employees and those who might be under a 1099? I didn't know if under Section A, so at the very top, page 1, where it says, in determining the reasonableness and time of a restrictive covenant sought to be enforced after the termination of an employment or business relationship. I didn't know if those 1099 employees might be covered under that business relationship.
Could we go out and get people's opinion?
I was going to say, we have got just the resource for you. We're going to go out of session and listen to our staff attorney opine on that matter.
Levin Crutchfield, Office of Legal Services. So the bill doesn't specify that. I could see them being included under business relationships, but within the language of the bill itself, it doesn't define or specify whether that would be included.
Thank you. Any other questions for our council while we are out of session? If not, we're going to go back into session. The Representative Vital.
Thank you, Mr. Chairman, and this is a question for the sponsor. I have no problem fundamentally where you're trying to go with this, with the sale of a business or restricting competition for an individual who has competitive information internally. Where I do have a problem, and maybe it's understanding, where we talk about the relationship to other partnership interests, membership interests, would that be just those interests that they were specified in the agreement, or other related investments that they have that might be parallel to this employment that were outside the scope of that employment?
Once again, we may go out and need legal's advice, but I'm assuming it is only what was in their agreement.
That's fine. I just want to clarify that.
Okay, that's the way I interpret it, but
All right, let's go out of session. Are you familiar with the question? You need it repeated. Could we repeat the concern there, Representative Vital? And then we'll go out of session now, and then could you give your opinion to her?
Sure. My question evolves around competitive advantage that you might have with a business, but you might also have a partnership interest or membership interest in other entities that might be parallel to this employment that might be unrelated. How are they affected if they're not outlined in the agreement? I'm just trying to understand.
Let me see if I understand your question first, Representative Vital. You're saying the agreement that you're speaking of is the post-employment contract for basically a non-compete. And you have other interests that are ancillary to that type of work. Are non-competes allowed to affect those businesses? Am I understanding your question? Is that what you're asking? Okay. So,
Yeah, but it costs you money.
11 Crutchfield, Office of Legal Services. From my understanding with how the bill is written, I'm not exactly sure how those would be affected. It doesn't necessarily speak to that directly. And just says that they can still enforce, the confidentiality or non-disclosure agreements, those things listed in subsection C, but I'm not sure how those would be affected if they would. I think it would depend on the agreement itself, but I can't really speak to it beyond that.
you good, Representative Vital?
Thank you.
All right, we're going to go back in session. And Madam Sponsor, we are making some sausage here today. And it seems, from what I can tell, the committee is all moving in the same direction, but there are folks who have some concerns with regards to items that would make this appear to be better and still accomplish your goal. There's no reason for us to rush this through. I think that there's some input that can be actually to make the bill better and better accomplish the goals that you've got. And so what I would ask our committee members, if you have concerns or a specific area about this, if you would get with Lovin and the bill sponsor, let's talk through it and see if we need to craft an amendment for this bill. I don't want to try to do this on the House floor. There's no need for that. We've got plenty of time in this session. But if we could get whatever cleanup issues you'd like to get addressed, I think if we roll this a week, I think we'll wind up voting on a better bill the following week. So unless there's objection to that, Chairman Lafferty, excuse me.
Thank you, Chairman. I just wanted to, since it sounds like the path we're going down is changing a little bit, I just wanted to ask a quick question that might help. I don't know anything about all this. I've never been valuable enough to have to sign anything like this. So I'm curious if the $70,000 part, with inflation what it is, time passing by, if I am the top salesperson at my, I don't know, just use the idea, Ford dealership, and I decide to go across the street to a Dodge dealership, but I'm making all in more than $70,000. Does that mean that I cannot leave my job there if I have one of these agreements and go across the street?
are you making,
Ms. Sponsor.
are you making more than 70,000?
Yes, yes.
Okay. That, if that is what your agreement
agreement.
said,
Okay.
then yes.
Okay.
And so it just depends on whatever you signed when you
Of course.
were hired by that dealership.
And just wanted to, if I could, Mr. Chairman.
Yes, sir.
$70,000 today sounds like a lot of money. In 5 years, that could change dramatically.
Right.
I just wanted to throw that out there for the record. Thank you, sponsor. Thank you, Chairman.
That's a great point. Chairman, we might want to index that so that it grows and becomes reasonable over time. But we set that as a base mark, and we'll tie it to some inflationary index, and then that way we won't have to somebody won't have to run a cleanup bill for this one.
Thank you.
And we have
The sponsor.
discussed that. That is something that was brought to my attention, and I went back to the group and said, how can we do this? It's hard to come up with an index. You can't use the price index because it's not a price. It's a wage, it's a salary. So it's different. So anyway, we can work on all that. If we get this week, we can work on all that and try to make it.
Madam Sponsor, you think we can
More
get it cleaned
palatable.
up in 1 week, or would you like 2?
Give me 2 if you don't mind.
Absolutely. Without any other questions for our sponsor, I think, yes, we're back in session. So without objections, we are going to roll House Bill 1034 2 weeks and make it a better, stronger bill to accomplish what our bill sponsor's wanting to do. Thank you for your input, committee.
Thank you.
Next on our calendar, House Bill 1523 by Representative Stevens. We've got a motion and a second. I don't see an amendment traveling with this bill, so you're in proper posture, Mr. Bill Sponsor. If you would, tell us what 1523 is going to do.
Thank you, Mr. Chairman. This bill makes updates to 2 outdated areas of law regarding how banks respond to subpoenas for financial records of their customers. First, it clarifies that a bank is not required to try to notify a deceased person, the deceased person's heirs, or their estate if someone requests the bank records with a subpoena. They still would have to confirm the service of the subpoena on a living customer. And then second, the legislation updates how banks deliver records. Right now, they have very cumbersome rules about how to package paper documents up. When the law was passed originally, electronic records were not a thing. So this updates the statute to allow the banks to provide these records electronically or by any means that the parties agree to.
Outstanding. Thank you for that explanation. So we are modernizing, streamlining. Have you got any transparency in there that we could throw?
I don't think we can add that in there today, but it will make it much easier for the banks and the customers.
Outstanding. Any questions for our sponsor? Who has a question? Somebody got their hand up? Oh, I'm sorry. Our Speaker Pro Tem is setting a pick for my viewing of you, Representative Hardaway. You're recognized.
Thank you, Mr. Chairman. Can you give us a more detailed insight into the service or the actions with the deceased or estates and how that differs from service now?
Mr. Sponsor.
Thank you, Mr. Chairman. So right now, the law is unclear whether a bank has to try to notify a deceased person, the deceased person's heirs, or the estate. If someone is living, the bank has to confirm that the subpoena was served on a living person before providing the records, I believe. If the bank believes the customer is deceased, then there's really no point in them trying to confirm service on the dead person.
Representative Hardaway.
Thank you, Chairman. So how would this affect the relationship of a probate court and the deceased estate?
Mr. Sponsor.
Thank you, Mr. Chairman. If the customer is deceased and someone subpoenas the records in a lawsuit, then the bank could provide the records to the issuer of the subpoena without verifying with the dead person that he got a subpoena. The dead person is dead, so you can't serve him.
Representative Hardaway.
Thank you, Mr. Chairman. Thank you, sponsor, for the biology lesson. But what I'm trying to get to is what are the obligations now between the banks and the probate courts, the banks and the heirs, the estate?
Representative Hardaway, let me see if I can answer this one, Mr. Sponsor. I believe that it is presently in the law unclear, and we are trying to provide clarity through the process introduced in this bill. Somebody probably ran into that somewhere, and we said, hey, we need to know what to do if this is what happens. Now then, I'm going to get my paper graded. Is that correct, Mr. Sponsor?
Yes, that is correct. If someone issues a subpoena in a probate case, then all of the people involved in the case would get notice of that subpoena being issued. But then the bank wouldn't have to try to contact those people or the dead person to confirm that the service was issued if their customer is deceased. And they would know that with a death certificate or if they've got probate court papers that show the estate is open.
All right, thank you, Mr. Chairman, and thank you for the supplement.
We have any other questions? Seeing none, we are going to open the board for voting. Madam Clerk, if you could open it up there, and please indicate your vote on the matter. Has everybody voted? Does anyone need to change their vote? Looks like we've got a bunch of committed people here. So, Madam Clerk, if you could close the board and tell us the results.
Mr. Chair, you have 23 ayes and no nays.
Well, don't worry, Chairman Powers. We got another one in here, so you'll show up as having perfect attendance today. All righty. House Bill 1523 passes, and it is on to calendar and rules.
Thank you.
Batting cleanup today on our scorecard is Leader Camper, who's bringing it forward House Bill 1108. We've got a motion and a second. Leader, you've got an amendment there. How about we get this thing amended and then we have you present it? Would that be okay with you?
That'd be okay.
All righty. Although, do I have a motion? Motion and a second to attach amendment number 1, which is coded as 009018. Attach that to House Bill 1108. To all those in favor, please give me an aye.
Aye.
Any opposed, noes? The ayes have it. Leader Camper, you've got an amended bill in front of us. Please share with us what we're doing.
Thank you, Mr. Chair. Mr. Chairman, members, what House Bill 1108 does is enact the Ola May Ransom Reintegration Act, which provides which prohibits a fee from being a business license being charged to any veteran of the U.S. military, including National Guard and Reserve. What the amendment did is made sure that the benefit only applies to veterans and National Guardsmen as well as reservists who are honorably discharged from service. And it changed the effective date to July 2026.
Thank you, ma'am, for
That's
that.
what the bill does.
Thank you, ma'am, for that clarification. We've got a question from Representative Lynn.
Are we, thank you, Mr. Chairman. Are we talking about sole proprietorships or partners in a partnership?
So proprietorships that, the $15 charge that they charge them.
Okay,
That
thank
the clerk charges.
Any further questions? Seeing none, hearing none, we're going to vote on the Ola May Ransom Reintegration Act. Madam Clerk, would you open the board?
Okay. Powers.
Look at that. Look at that. Got a lot of support. Never let it be said that the Commerce Committee doesn't support our veterans. Madam Clerk, would you record the vote? Let us know what happened.
Mr. Chair, you have 24 ayes and no nays.
All righty. Leader Camper, that bill passed and you are going on to finance. The amended bill will be headed to finance.
Thank you, Mr. Chairman, committee members.
Ladies and gentlemen, and Chairman Faison, what school is online listening to it? Our ETSU. Go Bucks. We expect you all to be able to have a pop quiz on what we did here today. Good luck with that. Other than that, folks, we will stand adjourned until this time next week.